Good afternoon. Today is Tuesday, April 2nd. April 8th. Thank you. April 8th, 2025. My name is Ward Keever, founder, president, and CEO of Covenant Wealth Strategies. And I am joined today by Jen Ellison, who's a member of our leadership team here at Covenant Wealth Strategies. And I will momentarily introduce the illustrious, the fabulous, the critically acclaimed Carolina Heinley. So just a moment on that. But we are glad that you're here today. We're going to be talking about estate and legacy planning. And our team here at Covenant Wealth Strategies will gladly provide comprehensive fee-based wealth management and financial planning strategies for our clients, which includes estate and legacy planning. Now, we are not attorneys. That's why we are joined by an attorney, but we do have a strong knowledge of tax and legal matters, and it's a very important part of your financial plan to have an estate plan. And so I would just say at a high level, estate planning will answer three questions. Number one, what happens if I don't wake up tomorrow morning? Number two, what do I want to have happen if I don't wake up tomorrow morning? And number three, what's the difference between the answers to questions number one and two, and how do we close that gap? So again, at a high level, a lot of times people are very intimidated by estate planning as we talk to clients. Probably 9 out of 10 people that we speak with do not have their estate planning documents in place, or if they do, they're way out of date. They're at least 10 years old. And so we talk to people, and last I checked, there's 100% chance that we're going to get to use our estate planning documents because everybody will pass away at some time. And so if we know we're going to get to use these, why are we not doing them? And people commonly say, well, because I don't know who to trust. I don't know where to start. I don't even know what questions to ask. And so today we're going to spend some time chatting with Carolina to talk a little bit about not only some of the questions to ask, but some of the answers. And of course, if you're working with the team here at Covenant Wealth Strategies, then you already know who to trust and know where to start. So without further ado, let me introduce Carolina. So Carolina is an attorney, and Carolina is an estate planning attorney. And I've known Carolina for 10, 15 years.
Yeah.
It's been a while. Carolina thinks it's 25 years. It just seems like 25 years. But the word that I use to describe Carolina is a word that you would typically never associate with an attorney, and for certain you would never associate with an estate planning attorney. And that word is fun. Carolina is actually one of the funnest people I know, and it's a blessing and a joy for me personally to have Carolina in my life. So Carolina focuses her practice on estate planning and administration. What's administration? That's after people pass away, you need to administer the estate. And so Carolina helps her clients to administer their estates. So she does the front end to make sure everything's in place, and then she does the back end to make sure everything goes according to plan. She has over 15 years of experience designing and implementing estate plans for clients from a wide range of financial backgrounds and life stations, and often works with several generations of the same family. And that's one of the things that we do here at Covenant is multi-generational financial planning and wealth management, and another reason we enjoy working with Carolina. Her practice involves advising clients on state and federal taxes, life insurance and retirement plans, lifetime gifting, asset protection planning. And with the assistance of her team, she handles all stages of the administration process and is experienced in areas of trust and estate litigation and business succession planning. So it's interesting as I read that list of areas of practice, because you look at it and say, well, wait a minute, life insurance and retirement planning, what's that got to do with estate planning? Oh, that's a good question. We're going to answer that question for you today. But again, you can see that there are multiple aspects of financial planning and estate planning that fit together really well. So that's why we're having this conversation today. Carolina is a graduate of Tower Hill School and attended Haverford College, as well as Yale University Divinity School, before graduating cum laude bragger, from Villanova University School of Law. And prior to joining McElroy Harvey, Carolina was a partner with Crossland, Heinley, and Bride. She is barred in both Delaware and Pennsylvania and volunteers at the Kennett Flash. She's a board member at the Kennett Flash, the Junior League of Wilmington, and the Raskob Foundation for Catholic Charities. Right? Okay. So there's a little bit more than I can read. I need to read this last sentence. Carolina Heinley, McElroy Harvey, Covenant Wealth Strategies, and LPL Financial are separate entities and do not represent each other. So the formalities are over. And I would also just say, in closing my introduction to Carolina, that she and her husband Court have 4 very active, not so little boys anymore. They're getting bigger and bigger, and a beautiful little girl. And their lives are full of joy and blessing. So with all of that being said, did you want to, well, I probably shouldn't ask you if you want to, I'll probably just go straight to the slides and not give you a chance at rebuttal. But again, we've known each other for a long time. We've presented together before in a variety of different settings. We do have a lot of fun together, mostly because of you. And so we're glad to be bringing this presentation today.
Thank you, Ward.
Yes.
And Jen, for getting this set up.
Yeah.
Yeah. And the kids have started calling.
Yeah, so the phone's buzzing.
You're probably wondering.
Okay. You're supposed to pick us up, Mom.
We're gonna ignore it. Okay.
Okay.
All right. Well, hello, everyone. Thank you for having me. Do I?
Yeah, I'll go ahead and
Okay.
when you're ready to share. Are you ready to share the screen?
Let's do it. Yep.
All right. So we're going to go ahead and share a screen, and this will be a PowerPoint presentation on estate and legacy planning. So there we go. That should be it. Yep.
All right. So we have this presentation. I'll try to follow the order as closely as I can, but I'm going to rely on Ward to contribute some things, and I'll probably bounce around a little bit. But I want to start with the question of what is an estate plan and who needs an estate plan.
Yeah, you got to pause for the disclaimer there for a minute.
Disclaimer, yep.
And by the way, we will have some Q&A at the end. And so if you have questions that you'd like answered, you can email them to jen@covenantwealthstrategies.com. And there actually have been some questions that have already been submitted prior to our program today. So we'll get to hopefully those as well. Oh, there you go. There we go.
Okay. So the question, what is an estate plan? I get asked quite a bit in tandem with the following question of who needs an estate plan. There's a misconception that only people who are, fantastically wealthy need an estate plan. It is a common misconception. I'm of the opinion that everybody needs an estate plan. Not everybody needs the same documents, but everybody needs an estate plan. And an estate plan covers 2 periods of time. It covers incapacity, so while you're alive but are not able to make your own decisions, and it also covers your death. So we think of estate planning documents sort of along a timeline. Okay. So who needs an estate plan? Yeah, is that how we do it? Okay. So who needs an estate plan? Chances are you do. You definitely do. I meet with a lot of clients who, oops, I went too far. I meet with a lot of clients who have minor children. If you have minor children, you need an estate plan. If only for the sole purpose of appointing a guardian for minor children in the event that both parents die. It's a difficult decision. People often don't want to think about dying and leaving minor children behind. So it is a conversation that is often delayed. But your opportunity to appoint a guardian for minor children, you do it in your will. If you don't have a will that appoints guardians, then the court of whatever jurisdiction that's relevant, they're going to pick the guardian for you. And the court doesn't always get it right. So you'll have, relatives sort of show up out of the woodworks to try to convince the court that they are the right person to take guardianship of your children, and it might not be the person that you wanted.
How long does that process typically take?
Depending on the state, but it could take 6 months, a year if it's contested. And I have actually, for a long time, I was very happy that I was never in a position where I had to deal with helping someone appoint a guardian for children. But we did it in the will, and both of the parents ended up dying within 6 months of each other. Unfortunately, they had guardianship provisions, and the process went pretty smoothly. But you should absolutely do it.
So without a will where you've named guardians for your minor kids, you're saying it might take 6 months or longer. And meanwhile, the kids are stuck in this state of limbo.
Correct.
Not sure.
And no one has authority to act on their behalf.
Where do the kids stay in that meantime?
Probably with the relative, but the relative lacks the capacity to enroll them in school or, authorize a medical procedure. So we're kind of in a state of limbo.
Yeah, like life is going on.
Correct.
But not for these kids.
Correct.
Because they're in this state of limbo because there's no guardian named, and the court has to go through this process to name a guardian. And until that process is completed, the kids are really in this state of limbo, and they're just are they staying with somebody where the court puts them, or the person that got to the house first gets them, or how does that work?
Yeah, we don't know. I mean, it's great questions.
Least desirable scenario. Let's make sure that we have wills with guardians named for the minor kids.
Yep. And going back to the point that you made in your introductory remarks, there are ways that we can leverage and implement life insurance policies as part of your estate plan to make sure that there are funds available to care for the children for the rest of their lives, to give to the guardians who are now going to take on these extra children. You can give them money to buy a new house or put an addition on their house. So there are ways that all of these assets we can deploy to make life for your children and their guardians as easy as possible.
Yeah.
But you can't do it if you don't have an estate plan.
Okay, we need an estate plan.
All right. And then another big one, if you have a special needs family member, I'm often asked what a special needs person is. But if it's a beneficiary who is going to need or is currently utilizing means tested benefits, which are typically Medicaid and SSI, supplemental security income. If that beneficiary inherits money directly, their benefits will likely be interrupted or they will be disqualified, which can have pretty catastrophic consequences. So there are ways that you can, in an estate plan, direct money to a special needs family member, but we utilize a particular kind of trust. So the money is there and available for this beneficiary without jeopardizing these benefits.
That's huge. That's huge. Special needs planning is almost like a specialized area.
Yes.
But if you have a special needs family member, literally just yesterday, I was on a phone call with clients. We were doing a review. One of the spouse had started a new job within the last, say, 2 years, and they had a new retirement plan, and we had never really kind of reviewed the retirement plan. And so they kind of got online. We weren't doing screen share or whatever, but we kind of went through some of the aspects of this new retirement plan. And I asked her to check the beneficiary. They had spouse as primary. And then the contingent beneficiary was her estate. And first of all, that's like almost never a good idea.
Correct.
But in this particular instance, they have multiple children and one child is a special needs child.
Right.
And they've done all the estate planning.
Yep.
And they have the special needs trust set up. But that money
Won't go into the trust.
won't go into the trust. It's going to go to that special
Yeah.
needs child and disqualify her for the benefits that she's getting. So while we were on the phone, we made sure that got updated.
Yep.
Yeah.
Yeah.
But it's interesting. I mean, how often do people change jobs?
Right.
Like it's a fairly common occurrence.
Right.
And so you enroll in your new company's retirement plan. And because you name the beneficiary, you know, you weren't necessarily thinking, you blew up the entire special needs trust planning. Yeah.
Yeah, which is, it has devastating
Yeah.
consequences. All right. So we will,
Actually, one more thing
Yeah.
before we move off of this. There's 2 points I want to make. One of your slides, your point on the right says, if you own property in more than
Yeah.
one state, can you just speak to that?
I
for a moment?
can.
Because we have a number of clients
Yep.
that own like a place down the shore or a place in, you know, out of state.
so owning property in 2 states is wonderful. But it can cause problems for probate purposes. So everybody has heard of the term probate, and we'll talk about probate in a little bit. But if your home jurisdiction is Delaware, for example, and you own property in Florida or New Jersey, if you are a resident of Delaware at the time of your death, Delaware does not have jurisdiction to dispense of your New Jersey property. So you will be putting your executor of your estate in a position where he is probating your main estate in Delaware, but then also doing probate in New Jersey or Florida or wherever your second home is, which is a nuisance because you're working with, 2 sets of attorneys and they're not fun.
No, attorneys are not fun, Carolina.
So
It's expensive,
it's expensive.
causes further delays.
It's time consuming. A lot of times, always probate is, you're mourning somebody that you've lost if you're related to the decedent. So it's an emotionally, physically, economically exhausting process. So, and a lot of your clients have real estate in 2 different jurisdictions. So there are ways that we can eliminate the probate process altogether by utilizing a trust. We set them up all the time. They're very common and they're very, very easy to work with.
So probate's not evil,
Not evil.
but we want to avoid it.
If you can,
If we can avoid probate, we want to avoid
we
probate.
absolutely should.
So if you have property that you own outside of your primary state of residence,
Mhm.
you need an estate plan.
Correct.
If for only the purpose of putting that property into a trust to avoid ancillary
You
probate.
got it.
Okay, super.
Yep.
One other question for
Yep.
you, not on the screen, but when our boys were younger and they turned 18,
Mhm.
they don't necessarily need a will. You can do a will, but more specifically, the healthcare directive and the
Financial
durable power of attorney.
Yes.
So can you just speak to that real
Yes.
briefly
Yes.
here? Because you look at it and say, hey, they're 18 years old. Why would they need
Yes.
estate planning documents?
Very good question. I'm glad that you asked. When you are 18, you are legally an adult, which means you have the right to decide who is making decisions for you in the event of incapacity, who gets access to your medical records. So I advise my clients, when you send your kids off to college, even though you are paying their tuition, you do not have the right to speak to their doctors, their physicians, or make their financial decisions.
You can't even get their report card
You can't. It's yeah.
because they're adults.
So fortunately, medical powers of attorney and financial powers of attorney are very, very easy to put together. But if you do them before your kids go off to school, and God forbid something happens to your child when they're away at college, you will have the authority to speak with the doctor or whomever, or make medical decisions.
Yeah. We had a client situation where daughter goes off to college. She is having fun with her friends. They go away for a ski weekend. She skis off the trail, no helmet, hits a tree, in a coma, in the hospital. Parents get the phone call, they get to the hospital, but I'm sorry, we can't give you any information about your daughter because she's an adult.
Yeah.
and it just takes a bad situation and makes it a bazillion times worse.
Yes.
Yeah, so
Yeah.
pretty much when your kids turn 18, they should get some basic estate planning
Very
documents in
basic.
place.
Yes.
And that can be done by Carolina or an estate planning attorney near you. You ready for the next page?
I'm ready for the next page. Okay. All right. So planning for incapacity. We were just talking about that. So it's really, we're talking about medical decisions and financial decisions. So property management. A common misconception, just because you are married does not mean that your spouse automatically has the right to make your financial decisions. I'm going to say that again. Just because you are married does not mean that your spouse has the right to make your financial decisions. So I have a power of attorney. It names my husband as my agent or my decision maker. So if something happens to me, he can step into my shoes and basically do anything that I could do. If I did not have a power of attorney and something happened to me, he would have to petition the court to become my guardian.
How long does that take?
A long time. A year, 6 months, a year. It's expensive and it's invasive. The proposed guardian has to complete a background check. People have to be put on notice. It takes a long time.
Seems like it would be a whole lot easier to just get your estate planning documents done.
And it's very easy to do.
Okay, in advance.
Well in advance.
Okay.
Yes, very easy to do. So just because you are married does not mean it's stunning to me that so many people have this misconception. Medical powers of attorney. This varies by state, but if you don't have a medical power of attorney, I think by most statutes, your spouse is the first person in line to make the decision. But if you're not married and you have a partner and you want that person to make the decision, there's no provision in a statute that I'm aware of that lets your partner, your non-married partner, make those decisions. So if that's important to you, just document your medical decision maker.
So if you are married and you have a spouse, that person's first in line, but what's the process do they need to go through in order to be named, or that's not as big of a problem?
It's not as big. I like having the medical power of attorney put in place. Because you can also provide instruction for the kind of care that you want. If you don't have a medical power of attorney, and you'll also hear them termed like an advance directive, if you don't have one, then your spouse gets to do it is the primary decision maker, and then it goes down to kids, and then from there it varies by state.
So that document you just mentioned, it might be known by more than one name. I can actually think of 4 names that it's known. Can you list out all those names and then clarify for us that these names all basically mean the same thing?
So I'm curious to know what 4 you're thinking of.
Okay.
All right. So there's a medical power of attorney, an advanced healthcare directive, a living will,
and a healthcare directive.
And a healthcare directive.
We typically know it as a healthcare directive, but until you said advanced healthcare directive, I said there were 3 names, but then you threw that in there, so I said 4.
So
but that all is the same name for the same thing.
Yeah. So these medical documents, there are basically 2 parts to them. The first part is a healthcare power of attorney. So if I'm incapacitated, I'm not end of life, I'm just incapacitated, who has the right to make my medical decisions? That's the healthcare power of attorney or healthcare proxy.
Okay.
5.
Okay. 5. Wow.
The second part of the document.
You jump to the second part. Okay. So ask a serious question is, do I have to be incapacitated, or can I just let anybody make the healthcare decisions for me because I don't want to make them?
For the medical document, you have to be incapacitated.
Okay.
For the financial power of attorney, you can write it so that it's effective even while you are competent.
Okay.
But for medical, you have to be incapacitated.
Before somebody else is making the decision.
Correct. And then the second half of the document is the living will. Everyone's heard of a living will, which is the same as your end of life directive or your advance directive. You're providing directions in advance. If you are end of life, what treatments do you want? What treatments do you not want? So we we sort of bundle those two parts in the same document.
Okay, so let me throw this question in for you. We talk about, so really when you're 18, you should at least get your power of attorney, healthcare directive. But then from there, we tell our clients that probably every 3 to 5 years, you should have your documents reviewed. Every 5 to 10 years, you should have them updated. There are triggering events, which might include marriage or divorce, might include birth or adoption of a child, might include moving from one state to another state, might include acquiring property in another state. Why would I need to have my documents reviewed if I'm moving from one state to another state? And I'm thinking about the fact that you're barred in Pennsylvania and Delaware, and we know people who have moved from Pennsylvania to Delaware or vice versa. Why should they get their documents reviewed? What's the difference between the states?
Great question.
That's why I asked it.
The financial power of attorney and the medical power of attorney, those tend to be state specific.
Right.
Delaware has different conditions that are considered end of life than Pennsylvania has, for example. And so when you move to a different state, I usually say to clients, at a minimum, those two documents should be reviewed. Trusts and wills usually are okay. But the powers of attorney and the medical documents, because they are state specific, you should just have them updated when you move to the new jurisdiction.
And I think those state specific rules are called statutes, right?
They are called statutes, yes. And the definitions of end of life conditions, which are defined in statutes, are primarily what we're talking about.
And they differ state to state.
Correct.
So, okay, super. Thanks. I got you off track there.
No, that's okay. It's okay. Okay, so planning for incapacity, we talked about. So we will now focus our attention on, let's go to wills. Let's go to.
Okay, you want
to go to, we talked about incapacity. Just want to make sure that I tend to talk a lot, so.
Okay, we've covered all of these slides.
Covered all of this, yeah. All right, we'll stop here for a moment. Well, this is going to segue into wills, actually, so let's just keep going here. Okay, so wills and probate. Ward said a few minutes ago that probate is not evil. It is not. I work with lots of clients who have to probate an estate, and it can be very quick and very efficient. But my suggestion generally is, if you can avoid probate, you should.
And to the extent that probate could be quick and efficient, what's the key to making sure that it's quick and efficient?
If you can minimize the assets that are passing through probate, so that it's just real estate, for example.
That's basically planning in advance.
Planning in advance, having an estate plan.
You can make it relatively quick and advanced.
Yep.
Okay.
So I am often asked the question of why should we avoid probate? There are fees associated with probate in every state. Probate is a fully transparent process, which means every document that is filed becomes a matter of public record. That means your will, your inventory, and different states do this differently, but in Delaware, there's an inventory that's filed, which is a list of all the assets that you owned when you passed away. It identifies your beneficiaries, it identifies their addresses. So it's completely transparent.
So for a nosy person, this could be some good, good reading.
Yeah.
Go down to the local courthouse.
Go down to the Register of Wills and
your next door neighbor to find out what they had.
Correct.
But, there you go.
So a lot of people are incentivized to avoid probate just for that purpose, because they don't want their personal business available to the public. Probate also takes time. In Delaware, the average is 8 months to a year. In Pennsylvania, probate takes about a year on average.
And that's if everything goes smoothly.
And that's if everything goes smoothly. Correct. which,
Wow.
usually
Yeah.
is not the case. So, and in Delaware, and this is again work at state specific, but the death tax that we have in Delaware at the state level is tied to probate.
Okay.
So you can avoid Delaware's state death tax, and I'm using quotes because we call it a fee. It's really a tax.
Yeah.
Where's the money go?
It goes to the state of Delaware.
Okay.
So you can avoid Delaware's death tax, which is tied to probate, by avoiding probate.
Okay.
For all of you Pennsylvania folks out there, Pennsylvania has an inheritance tax, which you can avoid.
Can't get around that.
So that is what it is. So
Gift during your lifetime.
unless you do lifetime
There
gifting,
you go, which is on the slide.
which is on the slide. Okay. So, but lots of people say, I just have a will and that's all I want, and that's fine. So if you have a will, you have an executor and you name your beneficiaries, and the executor's job is basically to take control of all of your assets, put it through this 8 months to a year process, and at the end, we pay the probate tax and then distribute to the beneficiaries.
So the beneficiaries have to wait until probate's over to get their money?
No, we can make advanced distributions,
Okay.
but there's always like a clawback provision that
Yeah.
says like, hey, if the executor needs some of that money back to pay off a creditor or to pay taxes, then you beneficiary agree to give the money back.
And so oftentimes, I think what we've seen is that although they might distribute some, in my experience, they don't distribute everything.
Correct.
So your beneficiaries are waiting. They might get some, but they're not getting everything until the probate process is finished.
I mean, if I'm representing the executor,
won't get
then they're not
everything.
they're not getting all of it.
Because we're not doing that clawback thing. We're like,
we're
hey,
not-
all that money we
we're not
sent you,
we're not-
last year.
Or not
we
clawing
get
back.
some of that back.
And then the other thing that is irksome about probate, and a lot of people have been through probate and they had this experience. When somebody passes away, everything is frozen for a period of weeks. Because we can't start the probate process until we have a death certificate. And the death certificate takes 2 to 3 weeks for the funeral home to produce. So there's always this period of time where the executor doesn't have access to the money. But there are expenses that need to be
That
paid.
seems problematic.
Life insurance needs to be paid. The attorneys want to be paid. There are final medical bills that need to be paid. But there's this 2 to 3 week period of time where the money is completely frozen. So
Are there good ways to address that?
there are, and we're going to
Okay.
talk about those. Okay. So, the question is, how do we avoid probate? So we're gonna flip to keep
All
going.
right, so we're just glancing through that. Might take a year. You get the pros and the cons. Okay, these slides, we'll make sure these slides are available for people. Can you avoid probate? Yes, you
You
can.
can. All right. So there are the easiest way to avoid probate is to name beneficiaries on your assets.
Okay.
There are some beneficiaries that just naturally call out for a beneficiary. IRAs, any kind of retirement plan, and life insurance.
Okay, some accounts. Yep, some accounts that call out for beneficiaries
So name beneficiaries
and not your estate.
and not your estate.
Because if you name your estate on one of those accounts, where's the money go?
Goes through probate.
Oh, and that's what we're trying to avoid.
Because then it's going to get taxed. And get that
All right.
probate tax.
So don't name your estate.
Don't name your estate. There are very few times that you should name your estate as a beneficiary on anything. A beneficiary designation trumps what's written in the will. I'm going to say that again. A beneficiary designation trumps what's written in the will. So if I have on my IRA that I name my spouse as beneficiary, but then in my will, I say I'm leaving my IRA to Ward,
Definitely. Good idea. Good idea.
Nothing in it.
This is the new financial planning technique that will be incorporated for all of our clients.
Will be flagged.
That won't happen.
Finance department just shut us down.
Yes.
What's in the beneficiary designation controls always, every time, because it is essentially an instruction that you put on file with the plan administrator
Mhm.
that when I pass away, you are instructed to pay out the asset to this person.
Okay. So that was a rather unlikely scenario. Let me propose a more likely scenario that in fact you and I were talking about, and we've actually seen this. And it happens, it's as frequently occurring as dandelions in the springtime, which will soon be, a feature of many lawns. Where you have a dynamic family situation where, for example, this is not the first marriage. And so they go to the time and effort of having their estate planning documents updated to account for the new marriage relationship, but they didn't go back and change the beneficiary on a life insurance policy or an IRA or something like that. And so just say, for example, if I were to pass away and I had been married previously, my will says everything goes to my wife, but my IRA beneficiary says it goes to my ex-wife because I never got around to it and updated it.
Yep.
So where does that IRA go? My
To
will
the
says
ex-wife.
it. Okay, so
Goes
even
to-
though my will says it goes to my current wife,
Goes to the ex-wife.
it goes to the ex-wife because the beneficiary said it goes to the ex-wife.
Correct.
So, as you were saying,
Yes.
the beneficiary designation
Trumps what's in the will.
trumps the will.
Yep.
Okay.
So that is a very, very easy way to pass an asset to a beneficiary quickly. That payout or that transition of that asset usually happens within maybe a few weeks or a month.
Pretty much just need a death certificate.
You just need a death certificate. And the death certificate is like the trigger for the plan administrator that satisfies that the death has occurred, and then they initiate the payout. It has nothing to do with the will, has nothing to do with the executor. And the beneficiary information is already on file with the plan administrator, so they contact the beneficiaries and take it from there. So that happens quickly. We're not waiting 8 months or a year. We're not paying the probate tax on it. It just happens quickly. Joint ownership is another way to avoid probate. We see this often with spouses in particular. When you have two owners on an asset and the asset is titled jointly with right of survivorship.
JTWORS,
Yep.
sometimes abbreviated.
Yep. Joint tenants with right of survivorship. And in the context of married couples, you will often see tenants by the entireties, which is the lawyer's way of saying married people. Anything that's titled jointly with right of survivorship when the first spouse dies automatically reverts to the surviving spouse. So we see a lot of jointly held assets when I do estate plans with clients, which is fine. We know probate will be avoided when the first spouse dies, but it puts the onus on the surviving owner when the first spouse dies or the first owner to meet with the estate planning attorney and say, okay, now I own this asset in my individual name. What can I do to make sure that it's not probated when I pass away?
To avoid probate. Just a quick question, because you mentioned that joint with right of survivor between spouses, but can you have joint with right of survivor that's not between spouses?
Yes.
So for example, if my father and I owned a piece of real estate joint with right of survivor, and my will again says upon my death, everything goes to my wife, now that she's become my widow, the property that my father and I own joint with right of survivor, does that go to my wife?
If you die first and your dad is still alive,
Yeah.
it goes to him.
Because it passes by title.
Correct.
Joint with right of survivor.
Correct.
So there are non-spousal
Oh,
applications
sure.
of
Yep.
that.
We see it. Siblings sometimes inherit real estate from their parents jointly with right of survivorship. You don't have to be related at all. It's just when you acquire the asset, you have to title it jointly with right of survivorship.
So not only does the beneficiary trump the estate planning documents, but the way the asset is titled trumps the estate planning documents. Okay.
So it's not uncommon in my practice when I work, and I work a lot with spouses, which is why I keep talking about this. But it's not uncommon in my practice when I work with spouses to do very little in terms of estate planning while they're both still alive, because we utilize beneficiary designations and joint ownership, because that's all they want to do for that moment, which is fine. And then we sort of defer the heavy lifting planning later. And that's a viable way to do it. The risk that we run, though, is either, God forbid, the spouses die together, or the surviving spouse just never gets around to meeting with the estate planning attorney. Okay. So the last way, or two more ways, lifetime gifting we'll talk about, but trust planning. I want to spend a little bit of time on trust planning because I think that it's really important. So you can go to page 17 and then we'll come back to lifetime gifting. Trusts are, everybody has heard of a trust. Again, there's this misconception that in order to need a trust, you have to be mega wealthy. Not true. I, for example, have a trust. I'm not mega wealthy. Okay, so trusts are the most common kind of trust that we utilize. They're very user-friendly. They're very flexible. It's called a revocable living trust. It's revocable because you retain complete control of it for the rest of your life. And it's a living trust because you set it up while you were alive. Some trusts don't come into existence until after you die. This kind of trust it exists when you are alive.
So can you just clarify that? Because I think that's important. If you have a will and you create a trust within your will, that trust is not in effect until after you die.
Correct.
But this, what you're talking about, is a trust that's not within the will.
Correct.
This is actually a separate document in addition to your will.
Yes.
And therefore it's operational during your lifetime.
Yes.
Because it's not in your will, it's separate from your will. Okay.
Perfect.
Thanks.
A revocable living trust is limited in what it can do, but it can do a lot. We utilize them primarily for probate avoidance purposes. So, for example, the house that I own in New Jersey, which I don't actually own, but one day. But this house, I'm a Pennsylvania resident. I own a fictitious house in New Jersey. I know that absent some kind of advanced planning, when I pass away, I'm going to have to do something in Pennsylvania, and I'm going to have to do ancillary probate in New Jersey, which no one wants to do. So what I do is set up the Carolina Heinley Living Trust, of which I am the trustee, the beneficiary, and the trustor, which means I set it up, I control it, and I benefit from it. And I transfer title of my New Jersey property from Carolina Heinley to the Carolina Heinley Trust.
Of which Carolina Heinley is the trustee.
Correct.
Okay.
And so what that means is, at least on paper, I don't own the real estate. My trust owns it. For all intents and purposes, though, I own it. I have to make sure the taxes are paid. I have to make sure, right? I have to make my obligations continue, but I write the checks as trustee. I sign trustee behind my name. The benefit is when I pass away, because it is not an asset that I own in my name, because it is owned by my trust, it does not have to go through probate. We don't have to do anything in New Jersey at all.
No ancillary probate.
No ancillary probate in New Jersey.
We've avoided probate.
Altogether. And the trust says, while I'm alive, I'm the trustee. When I pass away, I name my sister as the successor trustee. Soon as I pass away, she has immediate authority to carry out the terms of the trust.
So it's not going to, so it doesn't have to go through probate. It's not going to be delayed 8 or 12 months if everything goes smoothly.
Correct.
She's immediately, because you have passed and you named her a successor trustee, she is now trustee.
She's now trustee.
She can manage it.
Yep. And my trust
That sounds
says
a lot better.
it's much better. It's so, and really the benefit, I tell my clients, if I set up a trust for you, you're not going to see the benefit of this at all.
Mhm.
It's really what you're sparing your loved ones the time and effort and expense of going through probate. And my trust says when I pass away, I want everything to go to my kid. I mean, my husband is included, but we're just making this simple. My trust says when I pass away, I want everything to go to my 4 kids. So my sister, as the trustee, has immediate authority to sign a new deed over to my 4 kids. And then it's it. That's done. The trust has been fully administered
Or could keep the property in trust
for their benefit.
for their benefit,
Yep, which we'll talk about.
especially until they are at least the age of 18.
Correct.
Okay.
Yeah, my kids are very young still.
I know your kids. I don't think they
Yeah.
want to be in charge of your fictitious New Jersey house.
Yeah,
just yet.
I don't want them to have my fictitious New Jersey house. So, but the point is, a trust is a really effective, easy way to help with the distribution of your assets when you pass away. Makes things much easier. And the other reason that I like trusts is we can use them to be the beneficiary of assets. So going back 4 or 5 slides, we talked about how life insurance policies, retirement accounts, those are very easy assets to name beneficiaries on. I don't want my 4 kids right now to be the beneficiary of my assets. One, they're minors, so they can't inherit.
Okay.
But even if they were in their early 20s, I wouldn't want them to receive this windfall of money.
Can we just pause for a second and ask the question, because I've seen it. When you name a minor child as a beneficiary and you pass away, and so that asset then is supposedly payable to that minor child, like what happens? Because it's not what you think is going to happen.
It's not.
So what actually happens?
So it depends. It depends on what the plan administrator's practice is, but in general, the guardian takes control of the asset.
Even let's just say life insurance.
Yeah.
Right?
Yep.
So the guardian will take control because the kids can't.
Correct.
So if you're not 18, you can't legally
can't.
sign anything.
Correct.
You're like persona non grata
That's
in
right.
terms of,
Yeah. So someone's essentially going to step in, receive that inherit or that distribution, and then turn it over when you turn 18.
okay.
Which nobody, you should not give an 18-year-old, like an 18, it's just, it's a terrible, it's just not, it's terrible. So as you said, what, 36 months that kids just like
Oh,
spend
yeah,
an
we were chatting
inheritance?
about, so just kind of in the makeup room before the presentation, then we were chatting about a book entitled, we were chatting about a book entitled Sudden Wealth. And specifically, sudden wealth occurs in at least 3 separate phenomenons. One is oftentimes major league athletes. Secondly is lottery winners. And thirdly is inheritance. And this book by Susan Bradley, CFP, entitled Sudden Wealth, says that typically on average, all of that money is gone within 3 years, 36 months. So, in an 18-year-old, it's probably gone in under 12
Fewer
months,
than that,
right?
right.
Yeah.
So I work a lot with clients who want to make sure that whatever they're leaving for their children is protected against their kids' own impulses and, to borrow a phrase that I love of words, from predators and creditors. If you name your children on a life insurance policy as beneficiary or an IRA, when you pass away, as long as they're 18, they get the money and they do with it what they want. You can't impose any restrictions. They just take it and they go. The workaround to that is to set up a trust, a revocable living trust, and we name the trust as the beneficiary of these assets. And within the trust, we say, when I pass away, I want everything to be divided, in my case, into 4 equal shares, 1 for each of my children. And whatever money is in the trust or comes into the trust because of the beneficiary designation is going to get split into these 4 trusts. And then I get to decide what the rules of the trust are. So my sister as the trustee, is essentially going to manage each of these sub-trusts, these 4 sub-trusts, according to my rules, which I think it's the money gets held until the kids are 45. And distributions are only to be made for certain reasons. So the kids get the benefit of the money, but because it's not technically their money, it's still mine in my trust. It's not technically theirs, which means if they get divorced, the spouses can't make a claim for the money.
Not considered marital asset in a property settlement.
If they run into creditor issues, their creditors can't get at the principal. And if they need a car and they ask for $50,000, my sister will give them 15, right? Say, here's a car. So, but the money's available for like college tuition or like medical expenses. So there's a category of expenses that are considered legitimate and appropriate. So it's a way to, and this becomes important when we're talking about generational wealth and turning money over generation to generation. You want to preserve as much of the principal as you can so that it turns over to the next generation. So
we've actually had programs on multi-generational wealth planning, and we've talked about how you can convey your values, if you will, while you're conveying value, meaning monetary value. People tend to be a little bit more receptive maybe to influence when you are providing financial resources to them. And so the opportunity that we have to not rule from the grave, but to try to convey values, to try to convey influence through trust and through monetary influence.
Yeah.
So yep.
Yeah, they're just wonderfully fluid and flexible documents. I do a lot of trust planning also in the context of second marriages, where husband wants his second wife to benefit as much as possible from his money when he passes away.
Okay.
But he wants to make sure that when she dies, whatever is left goes back to his children. So the only way that you can accomplish that and be certain that you accomplish that is through a trust. I mean, a lot of times people say, oh, she's going to do the right thing.
Sure.
Right.
Until she meets a new guy.
Right. Until she meets a new guy, she doesn't do the right thing.
Yeah.
So trusts accomplish a whole host of objectives. For people who have to worry about a federal estate tax, we won't get into this too much, but for people who have to worry about a federal estate tax, we can introduce a number of different kinds of irrevocable trusts. A lot of people are familiar with an ILIT, which is an irrevocable life insurance trust. Some people have heard of a SLAT, which is a spousal lifetime access trust. But there are also irrevocable trusts that we can utilize when we're talking about trying to minimize federal estate taxes.
I'm just looking at our clock. We got about 5 minutes. So this has been great. And this is basically 101. So as Carolina just mentioned, we're not going to talk about ILITs or SLATs.
No,
we're not going to talk about grats or gruts or crats or cruts or NIMCRUTs or QPERTs or anything else. So this is estate planning 101, basically. Wills, powers of attorney, healthcare directives, and a basic understanding of revocable living trusts.
Yep.
Super.
But I think we actually got through it.
Okay, great. Are there any final things? And then we had a couple of questions and I wanted to make sure.
Oh, just really quick, thank you. Lifetime gifting. Lifetime gifting is a really wonderful way to reduce your estate. And a lot of my clients say, I want my kids to get, I want to see my kids benefit from the money while I'm still alive. So you can give $19,000 per person per year.
I thought it was 10,000. I didn't really. Just asking.
I was like, Lord.
I did. It did.
No, it's 19.
It used to be 10,000.
Yeah, I mean, it keeps going.
Oh, okay.
Yeah. So at one point it was 10. We're currently at 19,000, which means that you can give $19,000 to every person that you know every year without having to file a gift tax return.
Okay.
If you are married, you can split your gift and give $38,000 per person per year. That has the effect of reducing your taxable estate and also getting to see your loved ones benefit from the money.
What happens if you give more than 19,000?
Then you are technically required to file a Form 709 gift tax return.
Mhm.
It does not mean that you owe a tax, and this is a misconception. It is the gift giver who is taxed, not the recipient.
Oh, that's interesting. So the
Isn't
people
it?
who are getting the money, they're fined if you give them more than 19,000.
Correct.
Okay.
It's the gift giver.
And so if you're going to gift more than $19,000,
Mhm.
how much is that tax on the amount over 19,000?
It's probably not going to be taxed. So you file a 709 to record that, let's say you give a gift of $30,000. You are recording that you have now utilized 11,000 of your 12 point, what is the exemption?
13.5 million,
Yeah.
I think your unified credit.
Yeah,
Yep.
and that keeps it because it's indexed for inflation. It keeps going up. So you're not going to have to pay a tax. We keep track of the fact that you are now eating into your unified exemption, credit exemption.
Okay, but for wealthy people who are dealing with those matters, what is the tax? Gift tax or estate tax starts at?
It's like 35% or
I think it's 40.
40%. It's high.
It starts at 40 and
Yeah.
goes up to like 60%.
It's high.
Yeah, you thought income taxes were
Right.
bad.
Yeah, it's high.
Yeah, we want to avoid
Yeah.
gift and estate tax for sure.
Yeah. Okay.
Super. Well, we actually answered a couple of questions already. We said, what happens if you don't have a will when you die? And does everything just automatically go to my spouse or my kids? And we said, no. Wind up having to get somebody
If you don't have a
appointed.
will.
If you don't have a will?
Yeah, so if you don't have a will, then your home jurisdiction has a will for you.
Mhm.
Your state statute tells you where the assets go.
What's that called? Dying intestate?
Intestate.
Oh, not intestine, intestate.
Intestate.
Okay.
So you die intestate if you don't have a will. There's still a probate process, but the state determines who is eligible to be your executor and who your beneficiaries are.
So I have a recollection that if I don't have a will and I pass away and I think that everything is going to go to my wife, but maybe in the state of Delaware, 50%, according to the Delaware intestacy laws, 50% goes to my wife now that she's my widow, and the other 50%
kids.
goes to the kids.
Yep.
So if I don't have a will and I pass away and I have kids, not everything goes to the surviving spouse.
Right.
Yeah.
And if one of those kids is a special needs
And you
beneficiary,
just blew up
then that kid's going to get the money.
Yep, blew up their
And it blows up
Medicare.
the, right.
Yep. Wow. Okay.
Yeah.
So what happens if you don't have a will? You should have a will.
You should, yes,
Okay, you should have a will. Okay.
have one.
What happens if you don't have a power of attorney? We said that the spouse could be named pretty easily as the default, but you should still have a power of attorney.
If there's no financial power of attorney or durable power of attorney, someone's going to court to get a
Oh,
guardianship.
okay, so it's the healthcare
It's
directive.
healthcare,
Yeah, okay.
yeah.
The healthcare directive is the one where the spouse can be relatively easily
Correct.
appointed. But the financial power of attorney, if you don't have that and it's needed,
You're going to
then we're
court.
going to court.
Yep.
And that's kind of like probate. We want to avoid probate. We
Yes.
want to avoid court.
Yes,
Okay.
not
super.
my husband.
I was gonna say.
No, not your husband, the court.
We don't
Yeah,
want
yeah, yeah.
to avoid
Okay.
court.
All right, so another question that had come in, and actually, we literally just had this conversation yesterday with somebody. So husband, wife, in their 80s, worried about the fact that, hey, during probate or whatever else, my kids won't have access to this money. There's expenses that need to be paid. So could I just add one or more of my children onto my checking account? Or I've also heard, could I just add one or more of my children onto the, per se, deed to my house? Is that a good idea?
With few exceptions, I advise against naming or putting your kids on title of your real estate. You are inadvertently causing a capital gains tax issue for your child
Okay.
in the future.
Mhm.
But the concern usually is, well, how do I make sure that my kids are going to have ready access to the money when I pass away? If you add your child to your bank account, then that child becomes the owner of the account, which means joint with right of survivor, which means when you die, if you've got 4 kids, but you name Max, who is my oldest son, if you name him as the owner on the account, that money is his. He does not have an obligation to share it with his siblings.
Or to pay the expenses.
Or to pay the expenses. Yep,
Or
it's his. Correct.
the party company for the funeral.
Correct.
Or anything like that.
It's his money. And if he does the right thing and gives money to his siblings, he is now making a gift.
Okay.
So
that
he might have
$19,000 situations
Correct.
coming into play.
Correct. So if the concern is, I want to make sure that my kid has ready access to the money, make sure you can make all 4 of the kids transfer on death beneficiaries, TOD, or POD, pay on death. So all 4 of the kids each get a quarter of the account, and I would recommend only doing this for one account. They all get access to the account, and they're all going to have to sort of cooperate and each sort of contribute to the final expenses. If you don't think that's possible, then the solution is set up a trust, move that account into the trust, and then the trustee has ready access to the money.
Okay, so we can either set up a trust, retitle the asset into the trust. It avoids probate. We're not delayed by 8 or 12 months if everything goes smoothly, because the trust is operational as soon as you pass away, or you're incompetent or whatever else, or you resign, the successor trustee takes over immediately.
Yep.
Okay. Or we can do a TOD, transfer on death. But the idea of naming the kids, I mean, you could do that, but you seem pretty not inclined.
Well, I see that it usually doesn't work out the way it's supposed to.
Yeah.
We actually had a situation, husband and wife in their 80s, named their 2 adult children on a checking account. So not TOD, but joint with right of survivor. And the husband passed away. And the expectation was, well, all the money just goes to mom, the surviving spouse. But because the kids were named as owners on the checking account, they wound up having to pay an inheritance tax in the state of Pennsylvania. Because it was considered an attributed
to them
inheritance, even though they didn't actually receive the money. So, right?
So
all right. Well, we're at time. So I just want to thank Jen Ellison for being here today and helping us with technology and throwing a few questions in there. And I want to especially thank Carolina Heinley, estate planning attorney with McElry Harvey, with offices in Pennsylvania and Delaware. And I want to thank you for joining us, whether live or if you're listening to this recording afterwards. And I hope that you will agree that this is a valuable and important part of any financial plan is your estate plan. And as we talked about, a lot of times people don't have them because they don't know where to start. They don't know who to trust. They don't know what questions to ask. Well, if you're working with the team at Covenant Wealth Strategies, you already know who to trust, and we can help you figure out where to start. And hopefully today we've given you not just some of the questions to ask, but some of the answers to those questions. And again, we greatly appreciate Carolina, you being here. Always a good time. Even a dry topic like estate and wills and trust and everything else, Carolina always makes it a wonderful time. So please feel free to reach out to Carolina directly with any needs that you have for your estate plan. And if there actually was one more slide here. I think it was, if you have questions, you can email them to Jen at covenantwealthstrategies.com, and we will work to get you answers to your questions. So with that being said, we will stop the share and we'll come back and say, until next time, thank you very much for joining us.